Yep. Okay. Go!
Will you hand me my screen box?
Now go. Preach. Rah.
Court does call the case of Jerome versus Cassidy et al. Counsel, state your appearances. Ms. Rose,
Your Honor, Abby Cooper appearing on behalf of plaintiffs.
All right.
Your Honor, Francine Obar appearing on behalf of defendant Eric Cassidy.
All right. And Ms. Tote.
She was there until a moment
Yeah,
ago.
she just muted herself, muted herself. Ms. Tote, if you could turn on your camera and unmute.
Okay, my video is stopped and it was going just fine. I don't know what happened.
Okay.
Anyway, I'm here
Go
on
ahead.
behalf of myself personally and my business, Cambridge Family Holdings.
Okay, folks, I think we set this proceeding as kind of a status conference to see exactly where we were, as I'm recalling. And so if somebody wants to update me, that'd be great.
Sure, Your Honor. Yes, that is correct. We did schedule the status conference to check in with Your Honor to let you know where we are with the case. The intent was for us to put some effort into settlement negotiations. We have been actively doing that, Your Honor, and from plaintiff's perspective, we are requesting a little bit more time. We would like to mediate. We believe that we need a third-party mediator to really get this done. I think both parties have been active in those negotiations in good faith, and plaintiffs believe strongly a third-party mediator agreed to by the parties would have the greatest chance of getting this across the finish line.
And Your Honor, Ms. Cooper and I spoke yesterday, and it's been taking both of us a little bit of time to get responses to settlement, to get the settlement offer, to get a response to the settlement offer. So she just raised the issue yesterday, and neither Francine nor I have had a chance to talk to our clients about regarding mediating the case, and so that's something that we need to discuss.
Okay, so you haven't discussed with your client fully the idea of mediation. Is that what you're telling me?
Not since our conversation yesterday, no.
All right.
Your Honor, just on behalf of Mr. Cassidy, he is willing to consider mediation and put things off, but he does not by any means want to go further than 90 days out for this case to resolve.
All right. And Ms. Tope?
Yes, I agree fully with what Attorney Abby Cooper has put forth. We've discussed it, and I totally agree with her representation.
So it sounds to me, and Ms. Rosen, just so that I'm clear, while you haven't had the discussion regarding mediation, is there an objection to it, or you don't know, or?
I don't know. My sense is there was initially, and I just haven't had an opportunity to follow up.
Well, it would seem to me that if the feeling of the parties is that mediation would be the most helpful, I don't have a problem doing that. Now, as I'm recalling, and somebody can correct me if I'm wrong on this, there was a provision, I think, in the leasing agreement regarding mediation through a particular entity. But my understanding, as I'm hearing this now, is that it would be something outside of that,
Right.
as opposed to going through, what was it, U of M?
Yeah, it's the U of M Office of Student Conflict Resolution, and that was pursued, and that didn't result in a resolution of the case because we're still here.
And I guess my feeling is certainly I would not like it to go out any more than 60 days, but 90 is fine also, but I think it should be done. If mediation is done, it should be done and over as quickly as possible, because if it can't resolve that way, then we need to get ourselves on the trial track and start pursuing that.
Just to remind the court, Your Honor, we have not yet filed an answer in counterclaims, and then there's an issue of possibly removing it and possible consolidation.
Yes, okay. Believe me, there's not a way I can forget any of that. So, all right. So,
Yep.
I think mediation would be good to at least get on that track. I mean, I think with now that all of the parties are here, so I will order mediation. The question is, who do the parties wish to mediate, or do they wish the court to choose?
Plaintiffs had suggested and have contacted Jim Fink several months ago to see if he'd be open to the case, and he would be. Gail and I spoke briefly.
Jim Fink?
Yes.
The Jim Fink?
The one and only.
The one and only.
Oh my goodness. Okay, go ahead.
Is he in the courtroom right now? We just can't see.
No, thank goodness we have Miss Gazzari here today. So yeah, no.
We can try to find a mediator between all of us, I think. And if we get stuck, if we could get some suggestions from the court, but I think we have a couple other attorneys to reach out to as well.
Okay, so
Exactly.
here's the way I typically would do it, so that, because when people get stuck and it gets more complicated, the more people you have in it, is I would suggest if the parties could agree, that's fine. But what I would is I would order, as part of mediation, I'd give you a timeline to decide between yourselves, whatever that is. But each party would submit 3 names to the court. If you all can't agree, then the court would select from that list of folks. And so I can tell you my practice is, if somebody's name appears on all parties, that's likely going to be the person, and the like. So that's the way I handle it, so that we don't end up in a roadblock and then somebody's requesting to get back before the court to have something happen right away. I'll order mediation. I'll say that the parties are to select a mediator within 14 days.
Your Honor, are you?
Go ahead.
Are you ordering a certain proportion of payment for the mediator fees? That might be something that the parties may not agree on, actually, either.
All right, I'll get to that in a moment. And then, so the 14 days, you're to provide a list of mediators, 3 each, within 7 days to the court.
I'm sorry, after the 14 days expires?
No, within 7 days, you're to do that. So that
Okay.
the idea is that then if you cannot select at day 14,
Gotcha.
then the court will do it.
And I guess should this be from Ms. Tope, Ms. Cooper, and myself and Fran, like all 3 of us, or 3 separate groups, or Abby, or you?
Donna, or please correct me if you disagree with this, but I feel like we could do plaintiff side of the V and then defendant side, landlord side and tenant side. So I would say we'd submit 2 lists of 3 each, and Ms. Tope and I can consult.
Okay.
And then I would suggest that the cost be shared in equal measure once the court gets to that, certainly.
But are you dividing 3 or 4?
I was dividing it by 2, like landlord side, which would include Cambridge Family LLC and Jerome's, and then Cassidy side, which would be the tenants.
I see what you're saying. Okay. So I would agree in terms of payment that it is to be split equally, and that will make it simple that it will be landlord side and tenant side. That's how we will divide the payment.
Your Honor, it seems to me that a third a division might be more appropriate. The Jeromes pay a third, the Cassidys pay a third, and Miss Tope pay a third, since she's a counter defendant, or will be if we have to plead this case and bring her in as a third party. We will be suing her individually and her business.
Ms. Tope, you have something to say on that?
Yes, I do. I'm fully in agreement with what Attorney Cooper has said, which is that there is the landlord side and there is the tenant side, and it should be split evenly, no matter how many parties are landlords and no matter how many parties are defendants.
Your Honor, I think that disadvantages the Cassidys, because clearly Ms. Tope and the Jeromes could split it, so they would each be paying 25%. The Cassidys would be paying 50%. I think an equitable division would be a third each.
Yeah, Your Honor, this is summary proceedings. We've got a landlord versus a tenant. The tenant might have a counterclaim against the landlord, but it's a landlord-tenant proceeding. It's a landlord-tenant mediation. And Jeromes have been against their their will. It's been determined they are on the landlord side of the V. So that's why we're here.
I mean, the reality is that I also could, I guess, in certain respects, just divide it by party. Ms. Novar, I understand what you're indicating, but I don't. I think I'm gonna split it with the landlord side and the tenant side, and then you guys work out how you're gonna do that. It's just gonna be 50% on that side of it, 50% on that other side, and just do it in that respect.
Yes.
I think that's going to make certain things a little bit easier.
Yes.
All right. And what I'm going to then expect is that I'm going to get, and Ms. Novar and Ms. Rosen, you can chime in on this. I would expect, in terms of the list of mediators, that I'm going to receive a total of 6 names.
Right.
Because if I'm going to divide the mediation fees this way, then I'm going to get 3 from one side and 3 from the other side. So
Yes.
that's the way we'll do that and look at it. And certainly, Ms. Novar, in terms of the cost and payment of mediation, that's to be paid up front. But, there's also a method by which there can be recouping of those fees to the prevailing party if necessary. So that is something that can be looked at down the road.
Thank you, Your Honor.
Thank you.
All right. Anything else?
How would you like us to submit those names, Your Honor?
You can submit those names. I'll tell you what, get them directly to my chambers. And I'm going to, and we will, once we receive the names from each side, what I'm going to do is my normal practice is we will seal that and then put that in the file so that it's not broadcast out there for whatever reason. All right.
We can email them to Ann, I assume?
Yes, you can email them to Ms. Whalen. That would be suitable for the court. Okay. If somebody would prepare an order for mediation, just indicating that the court has ordered it to mediation, that the 14-day provision. I set then a mediation. The other piece to this is I would then set a mediation cutoff date, folks. And before I get to who will prepare the order on mediation, what I'm going to, Ms. Novar wanted no more than 90 days out, and I certainly agree with that. And I think it should be done quicker than that, frankly, if it's going to resolve. Contained within that order will be a mediation cutoff date of March 31st, 2025. I will then set a hearing on this matter for, give me my date in April.
It's either April 1st or April 8th.
April 1st or April 8th. I'm not having these people come back on April Fool's Day. I just, I think some bad things will happen. So what's the other date? April 8th? All right. So I'll set a hearing on this matter for April 8th, 2025 at 9 a.m.
Your Honor, would it be prudent at this time to set dates for timeline for filing counterclaims and answers and discovery in the event that I don't want to come back on April 8th and then have, to go 2 more months with discovery and whatnot?
I certainly could do that. Part of the problem is, or at least what I see as a potential problem is that once those are filed, that disrupts the mediation process in certain respects. But if you feel that it won't do that, then I don't have a problem setting dates.
Yeah, Your Honor, I from plaintiff's landlord's perspective, we were hoping to focus our efforts and our resources on mediation instead of volleying with various pleadings and back and forth, and use those funds to try and settle as opposed to defend or pursue.
All right. And I understand what you're saying, Ms. Novar, and I just think that I'm going to agree with that thought process of where one puts their efforts and resources into trying to resolve it. What I will do is I'm not going to set a timeline at this point. If the 8th, if it's not resolved, then the party should be aware that pursuant to the court rules, I will shorten time periods so that we can expeditiously get this matter to trial in terms for filing and other things.
Yep.
So you guys are going to be aware more so than myself as you go through the mediation process that it's not headed in that way. So you could start to prepare whatever pleadings and other things that you have so that you're ready to go. Okay.
Okay.
Right.
Anything else?
What time are we coming back on the 8th?
That would be at 9 a.m. And we can, with that one, we're probably, at this point, I'm going to order that in person. However, depending on what we have, then certainly you can check with my office regarding appearing via Zoom. And what I will do is, who wants to prepare the order regarding everything I just said? I mean, otherwise I'm going to pick somebody.
I'm happy to do it.
I'll let Miss Rosen do it. So Miss Rosen, if you would prepare the order.
Yep.
Because one time she was in Costa Rica and we had to do some things. So she owes the court. All right. Anyway, is there anything else, folks?
No, Your Honor.
No, thank
All
you.
right. Hearing
Thank
nothing else. All right. Good luck in mediation, folks.
Thank you, Your Honor. Thank you.
Are you kidding me?
Oh my God.
You have got to be kidding me. What is going on today? This is a joke. Today is absolutely an interpreter.
I need an interpreter when I cannot express myself sometimes.
Oh my God, sir, put that cigarette out. I don't give a crap that you are outside of this. What is wrong with everybody today? You know what, Miss Reed, we're going to start bringing people in court. You're going to learn how to act in a courtroom.
Can you hear it? Can you hear it? Ma'am? Ma'am? Can you hear it? Okay.
Come and go, so let this feeling grow.
I'm sitting up here, I'm the one that needs a drink.